Good morning, ladies and gentlemen. As Otswong'o has ably put it, I am a patent examiner with a bias in biology, particularly biotechnology. And I also have an interest in genetic resources and IP after having had a chance to be a member of the National Task Force on Development of Laws on the protection of genetic resources, traditional knowledge, and traditional cultural expressions. Now, in today's presentation, maybe we start with teasing our mind a bit. Kenya, we have got our big four agenda challenges, which are mainly manufacturing. We have got food and nutritional security, health, and remember we have got the COVID-19 challenges, and housing. Now, these, if these could be our main agenda items, how does IP come in? As we go down along, we materialize that we need solutions to actualize all these things. So that being the case, now my discussion today will mainly be on national patent application procedures, and I'll also include some issues related to patenting biological inventions. And I've heard that I've had expectations that we also want to be agents. So I'll also talk something small about the basic requirements of practicing as an agent and in our institute. I'm using the mode of presentation. I'll use the slides, but our discussion is not limited to the slides. You can, at the end of the presentation, I believe we shall have enough time to interact through the question and answer session. I believe it's from there that I will be able to actually address your specific issues. Now, the content is, of course, I'll have to introduce the basic terms that I'm using in the discussion. Then, as I said, we shall be talking about procedures on patent protection. So we shall have to look at the patentable and non-patentable inventions. What KIPI treats as patentable or non-patentable inventions. Then the minimum requirements for filing for patents, including patents involving living matter, annuities, and definitely the emerging challenges. And I'm very happy that we have got really able advocates here and people interested in IP. Other than being advocates, you also have some work to do for society, because IP is a regime and it keeps changing, and it needs champions who should direct the changes. Now, you've given me your expectations, but as for me, my expectation is that after completing this session, participants should be able to actually prosecute national applications for patents, utility models, and industrial designs, because that's the subject matter of the Industrial Property Act of 2001, as read with the regulations of 2002. Then I hope that by the end of the discussion also, we shall be able to identify the national route for industrial property protection, and also to appreciate that we are a receiving office for regional applications, read ARIPO, and international applications, read PCT. Then we should also be able to appreciate challenges in protecting biological inventions and innovations in Kenya. And then, as I said, be able to give suggestions for addressing emerging challenges, because you are the experts and you can influence the changes. So for introduction of the basic terms that I'll be using, we shall be talking, of course, I'm sorry, but just to clarify, to be sure that you're on the same page, I know you are able lawyers, but intellectual property in this particular discussion shall comprise industrial property, which is done at KIPI, the copyrights and related rights that are done at the Kenya Copyrights Board, KECOBO, the breeders' rights. I've intentionally said breeders' rights, not plant breeders' rights. So breeders' rights, so including farmers' rights and TK and cultural expressions. And so industrial property rights shall mean rights under the patents, certificates of utility models, technovations, and industrial designs. So for industrial property, we know that the act we use is an act of parliament that provides protection of inventions and innovations. And it facilitates acquisition of technology, grants, regulations of patents, utility models, and technovations, and industrial designs. Then inventions per se means a technical solution to a specific technical problem in any field of technology. Like I started by introducing the 4 big agendas. So you realize that for us to move forward, then we need technical solutions in manufacturing, in food and nutrition, in health, and in housing. Then innovations for this particular matter means utility models and industrial designs. So what is non-patentable? Let's try and sieve out what's not patentable, then we shall go down to what is patentable. Then discoveries, scientific theories, and mathematical methods are not patentable. Discoveries, it's believed that it's just like telling us what you have seen and you did not create anything. So there's no added activities that you have done to it. Then schemes, rules, or methods of doing business are also not patentable. However, as I said, talking to able lawyers and thinkers, I've underlined methods of doing business because COVID-19 has given us a challenge, and we have realized that our transactions, especially of money, we've been encouraged to use M-Pesa or mobile money transfers. So actually it's paperless. We are trying to, then as we see it, most of those technologies that have been very useful to us during this period of COVID-19, in my opinion, fall under methods of doing business. I put a challenge to you that I told you you are able people. Should the state remain as it is, because law is not cast on stones? Then that one I leave it to you. Maybe it could be a follow-up from the coordinator to see what we can do about methods of doing business. But in my opinion, the United States of America grants patents for methods of doing business. And given that we don't grant these rights in Kenya, we normally give them letters. You realize due to some requirements that we shall go through later on that smart young fellas who are having very nice applications that appear like methods of doing business are being given letters to have those rights acquired in the US. And I don't know if that should continue. So methods of doing business are not patentable. Then methods for treatment of human bodies and animals is also not patentable. Diagnostic methods are also not patentable, but products for use in treatment or in diagnostics are patentable. So mere presentation of information is not patentable. Public health-related methods or use of any molecular substances, whatever used for prevention of treatment and health hazards and all those other things are also not patentable. Then now plant varieties, as it were, as provided for in the Seeds and Plant Varieties Act of Cap 2, 326, but not parts. Parts thereof, products of biotechnology are patentable, but the plant varieties as per se are not patentable. Then inventions contrary to public order, morality, public health, and safety, principles of humanity and environmental conservation are also not patentable. And last, information prejudicial to defense of Kenya or safety is also not patentable. Restrictions on applications by Kenyans. Now, as I said there, no person resident in Kenya shall, without written authority from the managing director, KIPI, file or cause to be filed an application outside Kenya. When I was talking about the methods of doing business, I said now it falls here. They bring an application here, we realize that it's a method of doing business, then under this provision, they are given a letter to apply in the territories where it is patentable. Then invention shall be patentable if they have got 3 main requirements. We shall talk about later on. These are substantive examination requirements. So you can only have a patent if your invention is new. We do the novelty test. If it involves an inventive step or obviousness, and definitely it should be industrially applicable. Industrially applicable means it can be used in manufacturing, it can help us in food and nutrition security, it can be helpful in health, it can be helpful in housing, maybe construction, all those things, that's the industrial applicability we are talking about. Then if inventions involve living matter, then it's a requirement for it to be protected that you must deposit a microorganism. So all inventions concerning microbiological processes or involves the use of the same, the application will only be deemed completely disclosed if a culture of the microorganism has been deposited with a depository institution, not later than the date of filing the application. So if you're an agent and you are filing an application and the product or the process therein, as claimed, involves use of a microorganism, then for a complete disclosure to be achieved, the said microorganism has to be deposited in designated depositories. And definitely the application as filed should give some relevant information like the characteristics of a microorganism and the depository institution that you have deposited. So as per our law, the Industrial Property Act of 2001 and its regulation of 2002, our national depositories are the Kenya Agricultural Industrial Research Institute, KALRO, for agricultural inventions and environmental, and Kenya Medical Research Institute for medical microorganisms. Then I hope I'm not too fast. Otswong'o, am I okay? If I'm too fast, you can stop me.
No, you're okay. You're okay. Let me just interject that we are on Zoom and then we are timed. So when we log out in 5 minutes, remember to log in again. Yeah. It will go off and then log in again to continue. Thank you. Proceed.
Fine. Good. Now, so what are the rights to a patent? Of course, what's a patent? A patent is a technical document that describes an invention in full. We shall go to the details of how it is, but is a technical document with a full disclosure of the inventions, if possible, some ways of working it out, and definitely with some claims. So if you get this document, you have the rights to, the main rights to a patent shall be definitely to the inventor. So it's, as we talk about patents, it's very important to know that the most important player here is the inventor. And if two or more persons have jointly made an invention, then the invention will belong to them jointly. And if to the extent to which two or more persons have invented, then we fall to the earliest. In KIPI, what we rely on is the first to file. In case there are two inventors with the same invention, now whoever files first is the one who will have the right to that patent. So for the upcoming agents, it's important to know that once you suspect that your client has something that looks like patentable, it's always good to make sure that you file it, because the first one to file is the first one to get the patent rights. Then the right to a patent can be assigned just like any other property, or can be transferred. So we know that we are talking about intangible property. It's just like any other property, and it can be assigned, transferred, or such like things. So as I mentioned earlier, the inventor shall be named. In each application, there must be an inventor, unless it's been disclosed outrightly that they don't want to be mentioned in the patent document. So what about inventions made in execution of commission or by an employee? Now, the right to a patent for an invention made in execution of a commission of an employment contract shall belong to the employer or the commissioner. Like, for example, if KIPI wants something to be done, then it pays somebody, then I think whatever that person develops will belong to Kipi, because Kipi is the one that have commissioned that particular person to create that particular invention. Also, if you are in your institution and part of your work is not invention and you invent, then definitely you must have some agreement with the employer, because maybe it's not your work. But if you are employed as such, if you are employed as an inventor, then it will be, you'll be doing your work, and definitely all those inventions will belong to the institution that employed you to be an inventor. So that's what I'm trying to say. Inventions made in execution of commission or by employee, the employee shall have the right to equitable remuneration. And they'll take into account the salary, the importance of the invention to the institution. And in case it's not clearly defined, then our industrial property tribunal can give the basic directions on how the employee will be remunerated. Assuming that you are in a place where you're working and you end up with a very good invention that can help that particular institution, and yet it's not your work to invent, then you are entitled to remuneration, equitable remuneration. And if it was not clearly stated in your contract, then the Industrial Property Tribunal will help you to have the remuneration. Then inventions made without any relation to employment shall belong to the employee. Like if you just invented and you did not use. Now, for a patent application requirements, once you have got, we shall see how to draft. Then that will be the specification. You need a request for a grant for a patent, and it's normally done in IP form 3. And if IP form 3, if is an individual applicant, if is a company or an institution, then it has to be accompanied by Form IP4. And if the person who is executing the application is an agent, then we also need IP Form 39. So IP Form 3 is the form that requests for either a patent application, utility model application, and in some cases for provisional applications. Then IP Form 4 is the one that, for example, if it's a company that has applied, if the company is that fills the IP Form 3, then it's a company of IP Form 4 that states the relationship between the company and the inventor, because the inventor has to be mentioned. Then for the agent, like my friend who was talking about being an agent, then he'll have to fill IP Form 39. And now maybe I use this chance to answer the question about the gentleman who wants to be an agent. For you to execute a patent application at Kipi, you have to be an agent and you have to be a Kenyan. So, and the main requirements are that you must have a law degree or some science, or at least if you've had some experience at Kipi for more than 10 years, then you can also qualify as an agent. Then you should also have a current practicing certificate. We need a copy of your current practicing certificate. We need admission to the bar copy. We need your ID or passport copy. Then you'll fill IP Form 40. You yourself, to be an agent, IP Form 40, IP 39 allows you to execute the patent application. But for your application to be an agent, you need IP Form 40. And the application fee is 10,000. And I think that's the basic one. So I think the most important thing is that you need a copy of your law degree, the current practicing certificate, admission to the bar, and an ID or passport copy plus 10,000. I think that's all about that. For IP Form 3, if you get time, I'll share, then we see how to go through it, and also IP Form 4 and IP39. So filing fee for patents is Kenya shillings 3,000 for local applications and US dollars 150 for foreign applicants. Provisional applications is 1,000. So what's the difference between a final specification and a provisional application? So for patents, there are two documents. Either it's a final specification of the patent application or is a provisional application. Final specification means that you are already sure that that's exactly what you want to seek protection for. But for provisional application, this is where you think that some work has to be done before you file your final specification. And in most cases, it's in the research environment where you're fearing that maybe your competitor, like remember in the previous slide, I said that if there are two inventors inventing the same thing, the first one to arrive in KIPI is the one who will have the rights, because we use the principle of first to file. So to overcome that challenge, you can do a provisional application for what you know you have not yet finished. And then you have got an obligation that if you file today, you have got 12 months to bring in the final specification. So it gives you a window of 12 months for you to put the final specification. Provisional applications are very advisable, especially in universities, research institutions, or environment where you think that somebody might reinvent the same thing and get to keep it before you. Then the patent document should contain a title, disclosure, claims, drawings if they're there, and abstracts. So definitely we are now going into the environment of patent drafting. Now for a complete patent specification should have a title, the title of the invention. It should state the field of the invention, either is in agriculture, is in manufacturing, is in health, is in housing, is in construction. The background art, disclosure of the invention or summary of the invention, brief description of drawings, best mode of carrying out the invention, or where appropriate modes for carrying out the invention. In some quarters, we also call them embodiments, then the industrial applicability. So a title should be short and precise. It should be descriptive of the essential elements of the invention. Then the abstract is a summary of the invention. It should be descriptive of the essential elements of the invention and should contain most of the technical words or expressions describing the essential features of the invention. So remember, the title should be short and precise, and the abstract should be a summary of the technical features of the invention, and it should be less than 200 words. Now, the technical, if remember this, the title, the technical field, the background art. So the technical field here should specify the technical field to which the invention relates. If it's in agriculture, then it should be agriculture. If it's in medicine, you say this invention is useful in medical field. It could be environment, pharmaceutical, or any other field that your specification is all about. The background art is very important, especially to examiners, because in Kenya, our approach is problem to solution approach. You should state what is the problem with the current art. Like if it's in manufacturing, you should state what is wrong in the current manufacturing processes. Then you say, however, that problem has got a solution, and now you are giving that solution. So it briefly describes what is already known in that particular field, and now states what is new. And background arts, as far as it's known to the applicant, can be regarded as useful for the understanding, searching, and examination of the invention. So you start from the known, what is the current problem in the art, and what are you solving, and what is the solution that you have granted. Then we need a brief description of the drawings, because we say that a picture says 1,000,000 words. So if like examiners, we love drawings and diagrams because they actually help us to understand what it is. So these are optional, but where it's necessary for them, they are very helpful. So we need the drawings or diagrams and a brief description of them. After a brief description of the diagrams, you do a summary of the invention. A summary of the inventions, from my experience, after sitting here for some time, I've found it's normally a summary of the independent claims. Now, this one is a drafting trick that I'm giving you. I hope Otswong'o knows this. A smart drafter will start with claims. You do the claims, you do the principal claims or the independent claims, then you do the dependent claims. Now, a smart drafter will summarize the independent claims and put them into the summary of the invention. It has got two advantages. It makes sure that whatever you're claiming will definitely be part of the disclosure, because we realize that we cannot examine claims unless they are part of the disclosure. So that's the essence of the summary of invention. Then the detailed description should disclose the invention in full to enable somebody skilled in the art to read it and work out without undue experimentation. Like you assume that you are drafting this for your beautiful daughter or your son, he or she should be able to read that description and do exactly what you think. In patent terms, we say that the description should be enabling. It should enable Wanjiko. Wanjiko is the person skilled in the art. She knows everything about that art. So when Wanjiko or the person skilled in the art reads that invention, he should be able to work it without doing more experiments to understand what you do. So we say that it should be enabling. The description should be enabling. And if possible, use examples of where it best works. We call them embodiments. You can say, for example, if it's an article for writing, you can describe how it can be used for writing. If it's an agricultural manure or fertilizer, you should give some examples on what you did and the results that show that it has got novel activities over the other fertilizers in the field. It should also indicate the invention or the industrial applicability. Definitely, after you have disclosed what it is, you can say that it can be used in agriculture, in pharmacy, or in manufacturing, or everything. So description is very important. As I've said, it should be enabling. It should, and this also helps you to fight misappropriation of the same right. Because if you don't disclose it properly, whatever you have left out, somebody can use it. And so long as you did not disclose it, then it will not be easy for us to give evidence that you are the owner of the invention. So the description is very necessary. So claims, these are the boundaries. So remember, we started at the beginning, we talked about the title, the field of the invention, the background art, a brief description of the diagrams if you're using them, then a summary of the invention, the detailed description, and now we have got the claims. Claims are the most important to an examiner. They're the beacons that marks the boundary of your invention. If it's a farm, then these are the beacons that marks the boundaries of your farm. But in technology, claims are the ones that determine what you are seeking protection for. So claims define the matter in the invention that the applicant wants to be protected. So they should be very clear and precise so that an examiner can be able to identify what you seek to be protection. They should be clear and concise, not very, and in most cases, it has to be one sentence. Very clear and concise, one sentence. The scope of the claim should not go beyond what is disclosed. That's why I told you, if you are a smart strategist, you can start with the claims, then make sure that these claims form your summary of the invention so that when I'm checking, if I check in the description, I'll get that whatever you're claiming is also disclosed. Then the scope, now, the scope of protection, now, sorry, maybe I should clarify one thing at this stage. There's a small difference between patents and utility models. That's why you'll hear when I'm either talking about a patent or a utility model. They are nearly the same. Patents and utility models application is in IP Form 3. The difference is in examination. Now, for utility models, we shall just make sure that whatever you're claiming is clear, is precise, is concise, and that's all. But for a patent, we shall also, for a patent, we shall go for the novelty of these claims, the inventive step or non-obviousness, and the industrial applicability. So the patent has got 3 measures. But for utility models, it's the same, but we only go for novelty and industrial application. We don't go for the inventive step. So the claims are the same for patents and for utility models. But for examination purposes, we examine patents for inventiveness, but we don't examine them. We don't examine inventiveness for utility models. Maybe if you're not clear, you'll ask, then I'll clarify. So, so that's all. Claims should define the matter of the invention. They should be clear and concise, and the scope of the claim should not go beyond what is disclosed. And the scope of protection of a utility model is limited by the matter that has been claimed. And an application can have 1 or more claims, at least 1 or more claims. Now, examination is done in 2 bits. The first bit is called formality examination, and then the second bit is called substantive examination. Formality examination is quasi-legal, is mainly like law, where we interrogate if the inventor has been named, if there's an agent, is from IP 39 field. So mainly it's legal. Is the filing date requirements met? Because there are several things like, does it have what we've just said? The formality requirements is, does it have a title, the invention? Does invention have the field of the invention? Does the invention have the background art? Does it have a summary of the invention? If it's having diagrams, has it described the diagrams? Then is it disclosed? Does it have some claims? And does it have an abstract? Then after this one, you check, is the inventor, we at the formality stage. These are legal issues. Is the inventor named? Is there an agent? If there's an agent, has he filled the IP Form 39, allowing him to prosecute the application at KIPI on behalf of the applicant? So those are formality requirements. And definitely after fulfilling the formality requirements, you are now free to file for substantive examination. Formality requirements mainly is averagely 1 month, but then for substantive examination, we have got up to 5 years from the filing date, but it can be done earlier than that. And for now, in our law, there's also accelerated procedure. If you want, you can request for accelerated examination, as it's one of the new measures that we have undertaken recently. So examination as to substance, this one has to be requested on IP Form 8. Yes, yeah, the substantive examination is done on request by Form IP 8, and you pay 5,000 Kenya shillings if you're a local applicant, and $250 for foreign applicants. This is where we now do what I've said. We interrogate the novelty or the newness of the invention, and the non-obviousness or the inventive step, and the industrial applicability. Then we normally, you can get 1, 2, or 3 reports before we agree on the final document. So if on examination and a substantive examiner thinks that there are some issues to be corrected, then you have got 60 days to give the amendments that are required. So if there are different defects of the examination as to substance, then the applicant has got 60 days after the date of the invitation. So let's go back a bit. We have done the formality. It's maybe in 1 month or so. Then if you have fulfilled the formality requirements, you fill IP Form 8 and ask for substantive examination. Then when an examiner examines the novelty, the inventiveness, and the industrial applicability, and finds that there are some defects that have to be corrected by you as an applicant or the agent on behalf of the applicant, then you have got 60 days after the invitation to remedy the situation. And if by the end of the 60 days you still think you are not yet ready, you can ask for extension of time. Extension is normally given to a maximum of 3 times. I don't know what happens after 3 times. We believe that after 3 times, then definitely there should be a big problem, and definitely in most cases, it's abandoned. But we believe that by 3 amendments, you should be able to have come to the correct specifications. Then the term of protection for patents, that patent will last for 20 years from the filing date. And one thing is that once you have filed an application in KIPI, for example, in Kenya, remember that patent protection is territorial. You shall only be doing that one for Kenya alone. If you want to extend your protection beyond Kenya, then you have got 12 months grace period to extend your protection beyond Kenya. So Friday told me not to talk about ARIPO and PCT, but I'll only mention that we have got 3 routes. We have got the national patent prosecution route. We have got the regional, which is ARIPO for English-speaking countries and OAPI for the French-speaking countries. And we have got the Patent Cooperation Treaty for the international application. So that's the essence. Once you have done the protection in Kenya, you have got 12 months to think of extending it beyond Kenya. And then you either use the regional route or the international route. So I was trying to give an example of a claim. Here, I don't know if you're able to see it. So maybe if it's a container, then it's a container for serving infused beverages made from. So you can use numbers to indicate what it is. Like then it's comprising A receptacle 8, which you can see on the diagram, number 8 for holding liquid 9, and B, a lid, which is number 1 for the receptacle 8, provided with an opening 7. So you have to be specific. Having a first portion through which the string, which is number 11, of the infusion bag can move into and out of the container, and the second, which is capable of gripping the string, which is 11. So you have to be, what made me to bring this slide is the specificity of the claim. It should be specific and concise. Then you can withdraw your application before grant. It's allowable. But if it's been examined, there's a requirement that on the 18 months, after 18 months from the filing date, it has to be published. And it's normally published in the Kenya Gazette, but in Kenya, the practice is that we publish it in the Industrial Property Journal. Then what rights do you get after getting a patent? Of course, we say that the rights of a patent belongs to the inventor or by assignment to whoever it is. But then what does that patent document do to you? So the owner of the patent shall have the right to preclude. We call them, actually, they are limiting rights, monopolistic rights. So we monopolize, we block people from using that invention for a period of 20 years. And for the period of 20 years, when the patent has been granted in respect of a product, nobody should make, import, offer for sale, sell, or use the product without the permission of the patent owner, or stocking such products for the purpose of offering it for sale, or using the particular product. And if it's a process, nobody should use the process or do anything referred to in above here on a product without your permission. So in instance, if it's a process for a product, nobody should use that process to make that product without your permission. And definitely, these are private rights. You are supposed to police the rights yourself. Then after you have been granted an application, there is need for maintenance. You have to maintain that application. I said it's for 20 years. So on the second year, you are supposed to pay 2,000 to have your rights maintained. And by the 20th year, you should pay 50,000 to have the rights maintained. If you don't maintain the rights, then they fall into what we call public domain, and anybody else can use it, and you cannot claim anything. And if it's a utility model, you have to pay 1,000 first year, and by the 10th year, you have to pay 5,500. So a patent's life is 20 years, and the utility model's life is for 10 years. And these are the fees as scheduled from the first year to the 10th year for the utility model. So that's from 1,000 the first year and 5,500 by the 20th year. And for the patents, it's 2,000 from the second year and 50,000 at the 20th year. So as I said, enforcement of rights, you do it yourself. There are private rights, it's you to police your own rights, and the owner of the patent shall have the right to obtain an injunction to restrain the performance of the limited rights. So if anybody infringes on your rights, you have to obtain an injunction, you can claim damages, and you claim compensation. So that's the most important, aspect of it, is that once you have got that particular patent document and the rights, you can obtain an injunction on anybody who is infringing on those rights, claim damages, and claim compensation. And the courts have got a clear way of working out the compensation. Then the limitations. Everything has got limitations. Now, these rights cannot apply to research. Any research institution or any university, they have got all the rights to use that particular application without coming to you. So the limitation is that for scientific research or for teaching purposes, they are exempted. And the rights under the patent shall not extend to aspects in respect of what has already been put on the market. Like if you have got the patent rights on a pen, once I buy it from the shop, you have your rights shall end there. Or if that article is in an aircraft, land vehicles, or vessels, then those rights are limited. They are not practiced in that particular case. Now, the challenges that, yes?
Yeah. Another warning, so we will do the same, but this time I'm prepared. I will invite you immediately it goes off. Thank you.
The challenges that we have in patent prosecution in Kenya is that patenting biological inventions have got issues that have been raised by the new constitution. The Constitution of Kenya of 2010 has got issues to do with the intellectual property rights in Articles 11, 40.5, and 69 in the context of plant, animals, and microorganisms. Then patents and utility models utilizing microorganisms have to be deposited at CALRO or KEMRI, depending on whatever invention it is, and it's under provisions of Industrial Property Act Section 29 and Regulation 11. But the problem is that CALRO and KEMRI don't have capacity to handle the microorganisms. So that's the biggest challenge, that as much as we have got all these provisions in the Constitution, but it seems like patenting biological inventions is a challenge in that where we have to deposit the microorganisms, the institutions seem to be having capacity challenges in handling the microorganisms for the life of the patent. Then we also have a challenge in that KIPI is a checkpoint for Nagoya Protocol. And Nagoya Protocol is a protocol of the Convention on Biological Diversity, and Kenya is a party to the Convention on Biological Diversity, and it calls for respect for access genetic sources and associated traditional knowledge. And for this to benefit our communities, then it means that we also have to redefine and redescribe our laws to have the same incorporated. So we say that for keep it to be effective as a Nagoya Protocol checkpoint, we need to amend our laws to acknowledge the same. And then for community to benefit from the use of genetic resources and situational knowledge, patents, utility models, applications have to disclose the source of origin of the genetic source and the associated traditional knowledge, because this one can help us in sharing out the benefits accrued from the use of the genetic source or the associated traditional knowledge. Then if you look at the Constitution, the Articles 11, 40.5 and 69, you realize that it's talking about genetic sources as plants, animals, and microorganisms. And Kenyans have got the right to protect their genetic sources, which means that Kenyans have got the right to protect their plants, their animals, and their microorganisms. So microorganisms can be protected at keeping if the depositories are functioning. The plant varieties can be protected at Kekobo, but there is a link, there's a gap in that the animal breeds or breeders have got no regime. So there's a gap in that we don't have animal breeders regime, but we have got plant breeders regime. Microorganisms read by technology can be protected by patents, but animals have got no regime. So animal genetic resources, in which Kenya is very rich in, has got a gap in IP protection. Then the laws, there are some countries that already have laws for protecting both plants and animal breeds. And I've given you some 2 examples, maybe for further reading. And as I told you that by the end of the discussion, I hope that you should be able to also join the like-minded people in advocating for some changes in our IP laws. The Bulgarian and Czech republics have laws on protection of plant varieties and animal breeds. And so it's not a new thing. Some other territories have it. If we are to implement or enforce our constitutional provisions in Articles 11, 40.5, and 69 in relation to animal genetic resources, then we can borrow from the Bulgarian and the Czech Republic law on protection of plants and animal breeds. I think that's what I had for now, unless there are some questions where I've not been very clear.
Yeah, we can then now break and come back for discussion, question and answer.